What is your name, sir? Good.
Leonard Echeverria, boss.
I'm
Your
sorry.
Honor, Your Honor, I'm sorry.
Okay, hold on. Just tell me your name.
Leonard Echeverria, sorry about that.
Okay, that's okay. Make sure I got all the right papers here. Hold on.
Oh, wait, did we skip somebody?
Well, I had the next one as Samuel DeJesus,
Oh,
but
yeah, he bonded, I'm sorry.
he bonded. Oh, okay. Well, I need that one. All right, sir. You have been arrested on a charge of driving while license suspended with 2 prior convictions for that offense. I found probable cause as to that offense. Would you like to have the public defender appointed to represent you?
Yes, sir.
All right. I examined your affidavit, and I find that you qualify, so the public defender will be appointed. You also are presently out on bond on 2 cases involving driving while license suspended. One is 2019 CT 1731 in Osceola County. The other is 2019 CT 12, looks like, I don't know if that's a 3 or a 5. It looks like 3-4. 1, 2, 3, 4. 1, 2, 3, 4. In Osceola County, you made bond on both of those cases, $500 on one and $3,000 on the other. So,
May I be heard? Don't say
Oh,
anything.
no, I didn't.
don't say anything. Yes.
Sorry about that.
Without litigating the facts too much, this may be able to give an indication. The accused has informed me that his wife is currently in labor, and this current thing may have been an emergency. So if the court is inclined to revoke his bond, we'd at least ask that you don't set it at 0 and you set a new bond amount so that he could be there for the birth of his child.
She's 4 centimeters right now.
I don't see anything in this about,
Well, of course, the officer's not going to ask why.
Yeah, he just,
well, but if,
he just took
you know,
me.
if there's a visibly pregnant woman in the car, generally most officers, I think, would,
He didn't even.
You'd be
he
surprised how
didn't-
much police officers
he didn't
leave out
ask.
there.
well, I'll be honest with you.
Yeah,
It's,
I know it doesn't look great.
I know.
this is the 3rd offense.
I know, sir.
I'm afraid you're gonna have to stay in jail. I'm gonna revoke bond on the other 2 cases. And, I'm gonna set the bond on this new case, at $5,000, since the last one was 3.
5.
And we're gonna keep you off the road one way or the other.
All right, so.
If what you said to me is true,
I probably could call-
congratulations.
No, we could call right now, sir. I promise
No,
you.
no, that's okay.
No, because I'm nervous. Like, I don't want to miss the birth. I'm sorry.
I hope it's true, and I wish you the best.
Thank you, sir.
And the child will much appreciate you getting this
She will-
straightened out.
She will. She will.
All right,
Thank
thank you.
sir.
Sir, please tell me your name.
Timothy Gomez.
All right, sir, you have been charged with the offense of grand theft, 3rd degree of a motor vehicle. I find probable cause in that case. Your bond is set at $1,000. Would you like the public defender appointed?
Yes, sir. Yes, sir.
All right, then we'll look at your affidavit.
What?
All right. Yep, the public defender will be appointed to represent the defendant. The bond on that case is presently $1,000. You are presently out on bond on, oh my goodness, look at that, grand theft, 3rd degree of a motor vehicle.
No information has been filed in that case yet, Your Honor.
What is going on? Sorry. Promised myself I wouldn't say anything. Can you give me more information about the other case, whether it's anything?
I also see that we have, I'm sorry, that we have not filed anything. I can check to see when.
When was he arrest date was 5/2?
Yes, Your Honor.
Okay. Well, here's what I'm going to do. I'm going to go ahead and revoke bond on the old case. Obviously, if the charges are not filed within the next 3 or 4 days, he'll get out. If they are, then he probably shouldn't be out. And I'm going to stay the bond on the new case of $1,000. So what that means, sir, is that if the state doesn't file the old case, then your whole bond is $1,000.
Yeah, I know.
And if they do, then you're going to sit in jail until the judge in that case decides to let you out.
Yes, sir.
All right? All right. Sir, what's your name?
Larry Harmon.
All right, Mr. Harmon. Your name is familiar to me. Have you ever been involved in a case I was involved in? No?
I think the last time I was,
Come on, Judge.
No, no, he could be a victim or a witness or a victim's family or something. Never mind.
I guess the last time I was here.
Why are you so sensitive?
I'm
All
just
right.
trying to protect my client.
No, I understand. I understand that. Once I was a prosecutor for a long time. And so, sometimes that's how I may know you. Anyway, you've been arrested for the crime of grand theft of a motor vehicle. And I have examined the arrest affidavit, and I do find probable cause for that charge. Your bond is presently set at $2,500. You do not qualify for pretrial release. Would you like the public defender appointed?
Yes. Yes.
All right, we will appoint the public defender to represent you. You also have a hold out of Seminole County, so if you were to make bond here, I guess they'll just send you up to Seminole County. But your bond here is $2,500, and unless I hear argument from anybody else, I'm going to stay at $2,500. All right.
No,
I'm sorry.
Mr. Harmon wants to know if the court would be inclined to reduce it to $1,500.
On what, for what reason?
He is indicating to me that he has children at home and he wants to be able to save as much before he can go back.
I'm social.
State?
The state would note that there are 3 prior FTAs, as well as, it looks like several convictions, so the state would request that the bond be stayed.
Yeah, I'm going to stay the bond where it is. And I just want to say to you, if I knew him as a defendant, he would be in prison right now.
That's true.
Okay, so then it's no.
I mean, but you were the elected state attorney up until 2016.
That's true.
So, like, technically, all of the cases were your cases.
I didn't mean it that way. Thank you, sir.
I guess what you meant, like, if you personally handled the case.
No,
it
no,
would
his
be-
name just sounded familiar. And,
All right.
Okay, sir, what's your name?
A.B. Harrell.
Okay. And, sir, you have been charged, with, oh, my goodness. Oh, goodness me. You've been charged with retail theft under $300. I've read, this is a warrant, so you were arrested on a warrant. A judge had found probable cause that you committed that offense. I think there's actually a number of them. In 2019 CF 31, what is that? In 19 CF 7315, you're arrested on a warrant for retail theft. Judge having found probable cause. In that case, the bond was set at $1,000. Is that the same one? Yeah, that's the same one. In case 2019 CF 7278, you were arrested on a warrant for retail theft under $300. The bond on that case was set at $1,000. In case, is this the same? Did I already say 6945?
No, you did not, Your Honor.
Okay. In case 2019-6945, you were arrested on an arrest warrant for grand theft third degree, value between $300,000 and $5,000. There's a $1,000 bond in that case. In 19 CF 6771, you were arrested on a warrant for grand theft third degree. Amount of bond is $1,000. I think that's all of them. I think I got them all, yeah. Would you like to have the public defender appointed to represent you? If that, you're nodding yes.
Yes.
Okay. The court will appoint the public defender to represent you in all of these cases. I also note that you are presently out on bond on 2019 CT 2397, 19 CT 2398, 2019 CF 1447, 2019 CF 2150, 2019 CF 2188, and 2017 CF 13183.
Your Honor, may I be heard?
Please don't tell me the 2017 case hasn't been filed yet.
No, that's actually not what I was going to tell you. I was going to tell you that he's been adjudicated incompetent to proceed in a majority of these cases. I have one confirmation so far. I didn't confirm. This is what PTR told me. I just confirmed the 2017 case. He was adjudicated incompetent to proceed on January 25th, 2019. So at this point, he's presumed incompetent to proceed and cannot be held.
I'm sorry, what did you just say?
I said, so he was adjudicated incompetent to proceed on January 25th, 2019 in the 2017 CF case. I haven't verified the other cases at this point, but right now he's presumed incompetent to proceed. I don't know whether or not you can modify the bonds that were set in the warrant, but I would just ask that you take no action on these since he is incompetent to proceed. And the court has no choice. I have the case law. I just have to pull it up. The court has no choice but to keep him on conditional release. The legislature hasn't provided a.
Is he on conditional release or on bond? Because these say he's on
He would be on
bond.
conditional release because he was adjudicated incompetent to proceed. So that would put him on conditional release. Any bond would be, he might have bonded out at one point, but then he would have been placed on conditional release once he was adjudicated incompetent to proceed.
Well, what I'm going to do is I'm going to revoke the surety bonds that were issued on any of these cases. There's one where it doesn't really, none of the boxes are checked as to how he is out. So that's I'm going to do that on those cases. Any in which a bond was set, the bond is revoked. Obviously, if he's on conditional release, that's not subject to that ruling. And the bond amount on the existing cases will be maintained as, and on the old cases where I'm revoking the surety bonds, the new bond is no bond,
Okay.
okay?
I'll have your attorney address it. Okay.
Okay.
No, I will have I will contact your attorney and have them address it.
I can't bond out.
No, sir. Can't bond out.
I think they just haven't adopted the findings in his 2019 case, his 29 CT case.
Yeah.
That's all. Because the way the new procedure works is that they handle it in circuit court, and then they send that ruling down to the county court cases, because county court cases get stayed. So they just haven't adopted the finding yet in the 2019 case.
We don't have a good system of dealing with those things. All right, your name, sir.
Stefan Lilly.
What is it?
Stefan Lilly.
Oh, okay, well, that's, the next one I had in my pile was Javette Laponte.
She's mental health, Your Honor.
Oh, okay.
We just ask that she be reset for tomorrow.
Mental health.
Okay, so this should be reset for tomorrow?
Please.
Okay, just, I had determined, this is for the state's benefit, what? Wait a minute, oh, that's the old one. I did not find probable cause for burglary of a conveyance, only for trespass
On the point?
on the point.
Okay.
Yeah. I only find PC for trespass, not burglary. So take a look at it if they want to try to supplement it by tomorrow. It didn't seem like a burglary to me, but, so that'll be recalled tomorrow. Okay. Sir, you have been arrested on charges of possession of methamphetamine and possession of drug paraphernalia. I've looked at the arrest affidavit, and I find probable cause for both. Would you like to have the public defender appointed to represent you?
Yes.
All right, we'll appoint the public defender based on your application, and the public defender will be appointed. Your bonds at present are $2,500 on the possession of methamphetamine charge and $100 on possession of drug paraphernalia. All right, moving on. This would be, yes, sir, can you,
Ayub Rafiq Manraj.
Manraj, Mr. Manraj, you are charged with aggravated assault with a deadly weapon. In this case, I do find probable cause for those offenses. Based on your affidavit, you do not qualify for the appointment of the public defender, so you have the right to hire your own attorney for these charges when they come up. At present, you are being held on no bond on aggravated assault with a firearm. State, I believe I am required to set bond in this matter because it's not a life felony. I don't believe there's been any motion for pretrial detention filed, is that correct?
That's correct, Your Honor.
All right. Would you like to be heard on the amount of bond?
Your Honor, if I may have a moment. Your Honor, the bond schedule I'm looking at just says that it must be set by the judge at the first appearance. I do note that there are no prior, or there is a prior, a DUI, but other than that, no other history. Though reading the affidavit, the state would request at least a $5,000 bond.
Sir, can you tell me a little bit about your finances? What do you do for a living?
Auto body tech.
Auto body? All right. And you make about $500 a week?
Yes, Your Honor.
Okay. Do you own your own home?
I'm paying for it.
But I mean, you're the owner. You like pay a mortgage?
Yeah.
Okay. Do you know how much your house is worth?
Probably 140.
How long have you had the house?
2009.
Since 2009, so about 10 years?
Yes.
Okay. Do you know what the equity in your house is?
I'm not sure.
Do you know how much you owe?
I think maybe 40-something thousand.
Okay. So it sounds like you have a pretty good amount of equity in your house. All right, sir. I am going to set bond in this case at $5,000, $2,500 on each count. So that means you're going to have to come up with, you should be able to come up with $500, and then the rest would be security in your house. You cannot, during the period of your release, own any weapons or simulated weapons. Okay? You can't have a BB gun, you can't have a squirt gun, you can't have a gun or anything that looks like a gun in your possession. All right? If you have some in your house, give them to somebody else. You also cannot have any contact with the victims in this case. And I know this is a neighborhood area, but you can't talk to them, you can't look at them, you can't say anything to them at all, or to their parents or any member of their family that you know of. All right?
Yes, sir.
Any other conditions the state's requesting?
None, Judge.
All right, so that'll be the resolution of that case. Thank you, sir.
No, you'll get it.
right, sir, please tell me your name.
Joshua McNeil.
All right, Mr. McNeil, you've been charged with the crime of burglary of a conveyance. I've looked at the arrest affidavit, and I do find probable cause for that offense. Would you like to have the public defender appointed to represent you?
Yes, Your Honor.
All right, public defender will be appointed. Your bond is set at $3,500 on the single count of burglary of conveyance. There is a second case. See, I'm getting better at this now, aren't I? There is a second case in which you have been charged with 2 counts of burglary of a conveyance. The court will appoint the public defender on that case as well. I've looked at the arrest affidavit, and I find probable cause on that as well. Your bond on that case, on count 1, is $3,500, and count 2 is $150. So the total bond in both matters is $7,150. All right, understand?
Yes, sir.
Okay. Anything from any counsel? No, no? All right, very good then. Thank you. All right, sir, please tell me your name.
Ronald Christopher Olson.
Okay. I had in the next one, Mr. Negron. Is that not coming
He
up? for
wasn't
some-
on our court list.
Sorry?
I don't have that either.
Who?
I have it.
Here, you can find it faster than I can.
Is he somewhere else in there? or-
5880.
I got a special present. See, I got one you didn't.
Oh, he bonded?
He bonded.
Okay, that's fine.
Figured something like that. All right, Mr. Olson, you have been charged in this case with multiple offenses, trafficking in heroin, possession of cocaine, possession of OxyContin, possession of alprazolam, possession of a controlled substance, 2 counts of that, and 1 count of possession of drug paraphernalia. I do find probable cause as to each of those offenses. Sir, would you like the public defender appointed to represent you?
Sure.
Okay. Your enthusiasm is noted. It's been a long day for both.
Yes, it
Um,
was.
So, based on your financial affidavit, I appoint the public defender to represent you. Your bond in this case is on count 1, $100,000. On count 2, $1,000. In fact, on counts 3 through 6, it's $1,000 each count, and $500 on count number 7.
What was the last one? I'm sorry, Your Honor.
Sorry, what?
What was the last bond count for count
500.
7?
500. Anything from either council? No? All right, sir. Thank you very much.
We would just ask that you reduce the bond on the first count. He's never failed to appear in court. He only has 5 misdemeanor convictions and
No
2
felonies.
felonies. It says you got 2 here. So we'd at least reduce it to 50,000 or less.
Sir, you got any money?
I might be able to come up with some, but I can't come up with that.
Okay. Do you own any real estate?
No.
Okay. Do you own any expensive jewelry?
Nope.
Any? Do you have a car?
I do.
What kind of car?
It's a 89 F-250.
All right. That's a classic. Do you have? Where would you get money to make bond from?
Probably from my parents or something.
Yeah. I think that in order to lower the bond on this, the court should make a very thoroughgoing examination of the source of any funds. And we don't have the resources to do that right now, so I'm going to stay the bond as it is. But the trial judge can look at that later and have a more thorough examination of it. Okay, yes, sir, what's your name?
Norman Perez, Your Honor.
Okay. Okay, so I had Mr. Paul Bonded. Okay. Hold on. seem to be in the order that those other ones were. Oh, well. Okay, yes, sir, you are charged with fleeing and attempting to elude a police officer. I have looked at the arrest affidavit in this case, and I do find probable cause in the matter. Would you like to have the public defender appointed to represent you?
Yes, sir.
All right, based on your information in your application, the public defender will be appointed. Your bond is set at no bond. Counsel like to be heard on that?
Yes, Your Honor, Mr. Perez Morales is entitled to a bond at this point. The only reason it's no bond is because by statute, the IA judge is supposed to set a bond on this type of charge. It's no bond until you see an IA judge.
Oh.
But it's just like the DV cases. We would just ask that you set a reasonable bond amount.
All right, and state?
State has no objection to setting a monetary bond, just noting that there is an extensive history, it looks like.
Yes, I'm trying to, these are, huh? I take an hour. They're not in the same order. Everything else has been in perfect order, but those are not in the right order. I don't know. Anyway, what is the history that you have?
I've got 11 felonies, 3 misdemeanors, including use of a false name on a driver's license, operating a motor vehicle without a valid license, dealing in stolen property, false owner info, pawn items, dealing in stolen property, VOPs, burglary, petty theft, 2 priors, resisting recovery of property.
Sir, what financial resources do you have?
They're real low, Your Honor.
Okay. Well, based on your record, I'm not comfortable with setting a bond anywhere below $5,000 because I don't know enough about your finances, and with that record, the likelihood of your not appearing is fairly high, so you need to have a lot of skin in the game. So I'm going to set the bond at $5,000 on that offense. And did I appoint the public defender?
I think you did?
I didn't yet?
Yes.
I did, okay, I thought I did, but sometimes we do it over and over again, you forget.
With bond.
All right. Oh, there it is. Here they were.
We're not gonna deal with it right now. Yeah, just go ahead. Yeah.
All right, sir. Your name?
Petty?
All right, Donald Petty?
Yes, sir.
All right. On this case, you were charged with burglary of a dwelling and trespass in a dwelling after warning. I found probable cause on count 2, but I don't find probable cause on count 1 on the burglary count. I just don't, I don't see anything here indicating a intention to commit a crime within the dwelling. So do you want 24 hours to try to?
Yes, please, Your Honor.
All right. So we'll grant the state 24 hours to try and supplement the affidavit. So we may see you tomorrow morning. Right now, your bond is set at $5,000 on count 1 and $150 on count 2. You could bond out, right now if you want. Tomorrow, based on what I find, that bond amount might go down.
I have one thing to say, sir,
Sure.
if it's okay.
Yeah, you probably don't want to tell me about the facts of the case. We'll talk more tomorrow. Do you want to have the public defender appointed?
Google search my name, sir, please.
Well, don't Google search mine.
I'm not. I'm
No.
just letting you know, sir, I've fought this. This is my second time in this courtroom for the same thing.
Okay.
The state of Florida dropped my charges because the house was in my name. You're not allowed to steal land, and that's what the man has done again. He pulled up with 2
Okay.
officers, told me he stole my house.
Okay. Okay, well, we'll hold off on appointing public defender until next time. All right, can you tell me your name?
Lyrical Preston.
All right, you have been charged by warrant with aggravated battery on a law enforcement officer with a motor vehicle, fleeing and attempting to elude a law enforcement officer with lights and sirens, and resisting an officer with violence. This is a warrant. Probable cause has already been determined. You do not qualify for appointment of the public defender, so you'll have to hire your own attorney. At present, your bond is set at $10,000 on the aggravated battery and no bond on the fleeing and eluding until you see the judge that issued the warrant. And on the resisting an officer, it's $1,000. Thank you.
Okay, so what does this mean?
Pardon? Count two is still no bond. Yeah, that's in the warrant. Warrant's in no bond, so.
Would the court mind repeating the bond for Ms.
Sure.
Preston?
The bond on count one is $10,000.
Yes.
The bond on count two is no bond until the judge, till you see the judge that issued the warrant. And the bond on count three is $1,000. So you can't bond out until you see the judge that issued the warrant.
Wait, they didn't put an amount on here?
It just says no bond.
It can be modified. She's entitled to a bond. This is a non-capital or punishable by life offense.
This is my first.
Well, it's a
And it's
warrant,
just-
though.
I understand, so
So-
the warrant establishes probable cause, but you can modify it unless the judge in the warrant says that you can't.
Well, let's see what it says. Oh, let's see.
Yeah, it says at the bottom, may be modified by first appearance judge.
Oh, so it does, so it does.
So I would argue that she's entitled to a bond on the fleeing and eluding since it's non-punishable by life capital offense.
Sure. State, you want to be heard?
State would just note that, it's screened for out on bond in Orange and Osceola, but she has the warrant pickup in Miami-Dade that she's on.
I'll set bond on count two at $1,000. All right,
Thank you, Your Honor.
thank you. Your name, sir?
Anthony Ricks.
Okay, you didn't look like Patricia Rashid, so.
She's in the hospital, Your Honor.
She's in the hospital?
Yes.
Okay, so call that back up tomorrow. Mr. Ricks, you have been arrested on, let me see, I think this is multiple cases here. Long one. Yeah, two cases. The first charge is robbery with a firearm, and that, I've examined the arrest affidavit in that case, and I find that there is probable cause shown. Also, in the second case, you are also charged with robbery with a firearm. I've examined that arrest affidavit and do find probable cause is shown. Would you like to have the court consider appointing you a public defender?
Yes.
All right, I have your application in front of me, and I do appoint the public defender to represent you. At this point, you are being held on no bond on each of these two cases. Anything from either counsel? All right, thank you, that's all we have. Bonds will be stayed. Your name, sir?
Andrew South.
All right, Mr. South, you have been arrested on a charge of petty theft in the second degree, third or subsequent offense. I've examined the arrest affidavit, and I do find that probable cause is shown. Would you like the court to consider appointing the public defender?
Yes, sir.
Based on your affidavit, you qualify, so we will appoint the public defender to represent you. At present, your bond is $1,000. Thank you, sir. All right. Your name, sir?
Palmer Stuckey.
All right, Mr. Stuckey, you are charged with 4 counts. The first is possession of MDMA or ecstasy. The second is possession of cannabis with intent to sell. Third is resisting officer without violence. And the fourth is possession of cannabis. I find probable cause based on the arrest affidavit on all 4. Would you like the court to consider the appointment of the public defender?
Yes, sir.
All right, based on your affidavit, the public defender will be appointed. Your bond on count 1, possession of MDMA, is $15,000. Your bond on count 2 is $150, count 3 is $100, and count 4 is $100 as well. So that's a total of $350 is a total bond.
Okay. Your Honor, Mr. Stuckey would like me to ask for a bond reduction. I'll let the court take test. What would you like to tell him? On why?
I was just asking because on the first count is 15,000. The second one is 500. I mean, 150.
He reduced those, so.
Oh, you reduced those. Oh, but it's just 15,000. I don't have that time. I just recently, lost my job, so it's like, I'm just making the ends meet off those last 2 checks, I made, and I pay rent with that too, so.
Yeah.
And 15,000, a little steep, 10% of that is 1,500, but with all these, it'll be 1,800 in total, and 1,800 is a little steep right now,
Well, I'm going to deny your request now, but that doesn't mean you can't bring it up in front of the trial judge in the case. He'll have more information, have more time to do a more complete hearing, and the public defenders also have a chance to put a presentation on. But at this point, I'm going to leave it right where it is.
All right.
Bond will be stayed.
So when last checks were?
She's gonna come today.
Mr. Bryant?
Yes, sir.
All right. You have been arrested on a failure to appear on a possession of cocaine case. The court has ordered your arrest and that you be held on no bond. The court also has I guess this is a new case, yeah, involving 3 counts of burglary of a conveyance and 1 count of grand theft. The court has examined the arrest affidavit in the case and does find probable cause. Would you like to have the public defender appointed in the new case?
Yes, I would.
All right, based on your application, the court will appoint the public defender in that case. Your bond on the failure to appear is no bond until you see the judge. Your bond on the new cases is $3,500 on count 1 and $150 on the other 3 counts. That bond will be stayed unless there's any motion to do otherwise, and you'll be in jail until you see the judge on the case you failed to appear on. All right? There you go. All right. Sir, your name?
Jeremy Tillman, sir.
All right, Mr. Tillman, you have been arrested on a count, actually a number of counts. You've been arrested on 15 counts. Grand theft, possession of a firearm by a convicted felon, possession of heroin, possession of methamphetamine, and 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 counts of possession of ammunition by a convicted felon, and the last count is possession of cannabis. I find probable cause for each of these offenses, though I'm going to only set a bond on one of the possession of ammunition charges and RR on the rest, because I'm not sure ultimately you can be charged with every bullet that was found.
Yes, sir.
But I do find probable cause for the rest of it. Would you like the court to consider appointment of the public defender?
Yes, sir.
All right, based on your financial affidavit, the court will appoint the public defender to represent you. Your bonds in this case are as follows. Count 1 is $150, count 2 is $150, count 3, possession of heroin with a weapon, is $15,000. Possession of meth is $150. Possession of ammunition is $150. All of the other possession of ammunition cases will be changed from $150 to ROR. And on the last count is possession of cannabis, and that is $100.
Yes, sir.
All the bonds will be stayed with the exception of the possession of ammunition counts. The repetitious ones will be ROR. Anything else? All right.
It's because he reduced one for you, that's why. Because those other ones were originally higher, so he reduced them for you.
Thank you, Your Honor.
Thank you. All right, are you Mr. Turner?
Jordan Turner.
All right, sir. You have been arrested on a charge of retail theft. I find probable cause exists in the arrest affidavit. Would you like the public defender to be appointed?
Yes, sir.
All right, court will appoint the public defender based on your application. Your bond on the retail theft count is $1,000. You also are presently on bond on 2018 CT 1237, driving while license suspended or revoked with knowledge. Oh, wow, has that actually been, is it a
Well,
traffic
it's an
citation?
yeah, it's a citation, so I can't argue that it hasn't been filed on in good faith, because an NTA is a charging document.
Nice for a change. All right, so I'm going to,
I would ask you take no action on it since the two cases are unrelated.
yeah, I'm gonna do that.
Thank you.
So your bond will remain as $1,000 on that. Now, that doesn't mean that the trial judge can't revoke your bond
It's okay.
based on that issue, so. All right. All right, your name.
Shanika Turner.
All right, Ms. Turner, you have been arrested on a charge of retail theft of under $300. I do find probable cause for that case. Would you like to have the public defender appointed to represent you in this matter?
Yes.
All right, based on your application, I will appoint the public defender. I also note that you're presently on, well, let's see, it says competency hearing.
She's been adjudicated incompetent to proceed in that case on October 1st, 2018.
In
So
both
she's
of
on
them?
conditional release.
Okay.
I didn't check the 2017 CF, but the 2018 CF case, okay.
Yeah.
So at this point, she's presumed incompetent, so I'd ask that you reduce the bond in the new case as well.
Well, State?
Your Honor, I don't see the adjudication for the motion of incompetency, though.
Are you in the new case or the old case?
18 CF.
I mean, my note says competency hearing,
Right, that's
which
what I have.
might imply that it was set for hearing but not yet determined,
Let
but,
me double check, but when I looked it up at the beginning of this morning, it said they were adjudicated on October 1st of 2018.
that's very possible.
Because they could have statuses, because that's what they're supposed to do.
Yeah, that could be.
I go every other month to court.
She says she goes to statuses every other month.
Yeah, every six.
I see that there
Yeah, here's
were,
the
that
order.
there was a second evaluation, but I don't see the order.
It's right here.
So that's the competency order?
It was just handed to me by PTR, I'll pass it around.
Okay, no, it's all right. Well, I don't need to see it. So I won't take any action on the existing cases because they don't indicate anything that would, it's inconsistent with it being found incompetent. But I'm not going to alter the bond on this case. I'm going to leave it at $1,000 bond. Basically because these are so similar to the other crimes. This is different, right, different. All right, please tell me your name.
Teresia Turner.
All right, you were arrested on possession of controlled substance and possession of cannabis. I find probable cause as to both.
Oh, sorry, I didn't.
So no, I'm just looking.
Oh.
So you came to BRC to see somebody and you stayed?
I came to.
Don't say anything. Don't say anything. I'm just pointing out the irony of life. Okay, I find probable cause as to both of those. I note that you also are on bond on a battery case, 19 MM 3565.
Yes, Your Honor,
Yes,
yes.
Judge.
All right? Does the state want to be, well, the bonds on this case, on possession of controlled substance is $1,000, and possession of cannabis is $100. I'm going to stay the bonds on those two, so that will be your bond. Does anybody want to be heard on the existing cases?
No information's been filed.
State would just request that it be revoked.
Well, if the information hasn't been filed, then I'm not going to revoke it.
Yes, that's correct, Your Honor.
All right. All right, thank you. Okay. Sir, your name, please.
Michael Valadez.
All right, Mr. Valdez, you have been arrested on charges of grand theft, third degree of a motor vehicle, possession of alprazolam, and possession of cannabis. Court finds probable cause as to all of them. Would you like the public defender appointed to represent you?
Yes.
Yes? Did you say yes?
Yeah.
Okay. Based on your affidavit, I will appoint the public defender. In this case, your bonds on these charges are $2,500 on grand theft, $150 on possession of alprazolam, and $100 on possession of cannabis. You also are on bond on a charge of grand theft of a motor vehicle in 19 CF 6282. On the new cases, the bond will be stayed.
No information's been filed in that other case, so we asked you take no action. They're just slow with making their filing decisions.
Well, I would note the arrest just happened this month, so.
And this 33rd day is coming up.
I'm going to put a paperclip over my lips just so I don't say anything. Okay, anyway, so I'm not going to take any action on the existing case. The bonds will be stayed on the new case. And did I ask you if you wanted a public defender?
You should.
Oh, good. I'm getting a little bleary here.
I'm good.
Yep, you can go.
All right, please tell me your name.
Hector Morales.
Okay. Okay. The next one I had was Gerald Watson. Is that?
bonded, Your Honor.
He bonded. That's good news. I wish more people would follow that. Oh, my God. I'm just standing up to stretch. All right, sir, you have been arrested on capiases for failure to appear. Those capiases were issued by the judge. He or she set the bonds at $250 on count 1 and $500 on count 2. That is all, that's all we need to discuss. He has another. Oh, never mind. Spoke too soon. Oh, there it is. Oh, my gosh.
I had 3 counts. Is there another?
Oh, yeah,
case?
there's a third, possession of cannabis. It's a separate affidavit. And the bond in that is set as $500. So if my math is correct, your total bond is $1,250. All right. Okay. All right. Your name, sir?
Frankie De Hoyos.
Okay, so I had a Charles Davis.
He bonded, Your Honor.
Bonded out. Music to my ears. Of course, I had to read this silly thing. Could have done it before I read it, right? Maybe. Anyway, okay, sir, you have been charged. I think we have 2 cases. The first is a driving while license suspended charge. I have read the arrest affidavit and find probable cause on that case. Your bond is set at $500. Would you like to have the public defender appointed in that case? I'm sorry, was that yes?
So you gotta say it. Tom.
Yes.
Yes, all right. Based on your affidavit, the public defender will be appointed, and the bond is set at $500, and that bond will be stayed. We have another violation of probation affidavit. This is from another county. Judge issued a order for your arrest, and I'm trying to think of what county this is, but,
It was Lake County, but he was being supervised by Orange County.
okay. Well, so you'll be going back to Lake County, and I believe that is no bond. So you won't be
When-
getting a bond until you go and see the judge in Lake County.
When will I be able to go to Lake County?
I don't know.
They'll come pick you up.
Yeah, once your Orange County case is satisfied, then they'll send you to Lake County to take care of that.
And when you mean by satisfied, what does that mean?
Well, when you it gets dropped, you plea, your lawyer can talk about it later.
When the case is over.
Can I just pay the bond?
Okay, so
You
you
won't
got
be able
both.
to get out and you won't get time, so don't pay the bond.
I won't get any time?
Yes, because the thing is, if you pay that bond right now, you're not going anywhere, and then you'll stop gaining time on that case, so don't bond out.
All right. Sir, what is your name?
Edwin Bellamy.
I'm sorry?
Edwin J. Bellamy.
Okay, I had a Victor
He bonded, Your Honor.
Lescanzo Bedoya.
He bonded.
I know, but I want to pronounce the name. I want to show that I can do it. All right. Let's see, okay. Mr. Bellamy, you are charged with, let's see, is this the, this isn't the ones that are.
He bonded too.
In this case, you are charged with trespass in a dwelling. I have examined the arrest affidavit. I do find probable cause. Would you like the court to consider appointing a public defender to represent you?
Yes.
All right. Based on the affidavit, the court will appoint the public defender. Your bond at this point is set at $500.
You wanted to know if you could resolve this case today?
State?
There's no offer from the state at this point, so it'd just be to the bench.
Well, you can, you know, I'm going to say no. I mean, I'll take your plea now, but I won't sentence you now because your victim, the victim of this case, has a right to be here to speak. So if you want to enter a plea today, I can, but I won't sentence you. So I'm not sure you want to do that.
No, Your Honor, he doesn't want to resolve his case.
Okay, very good.
Been trespassed, so.
That's okay.
There you go. Okay, Mr. Murillo Martinez.
Tony Jackson.
Tony Jackson.
That's who I have too.
Murillo wasn't on our court list.
Okay, well, let's see. What do we
Mine
got here?
either. He must have bonded.
This- Well, I have a whole bunch of stuff here and, hold on. What's going on here? I've got a whole, got Murillo Martinez, I've got Jesse Morris, David Skelly.
Jesse Morris bonded, Your Honor.
Okay, so Jesse Morris bonded, that one's out.
Skilly is mental health, Your Honor.
Skelly's mental health. Murillo Martinez, we don't have that anywhere?
No, what's the inmate's number?
Here, you'll have to, your eyes are getting blurry.
1901-5887.
Bonded? Yes, sir. All right, good news. Jamal Tapper,
She's on the wall. I mean, he's on the wall back here.
he's on the wall back there, okay. And Catherine Todd.
She's on the
Catherine
wall.
Todd. And what was your name, sir?
Tony Jackson.
Tony Jackson. Well, I'm gonna have to dig for you a little bit here, hold on. Oh, it was the one that was, attached to something else? Oh, okay. All right, now we got you. All right, so, sir, you've been arrested for the offense of simple trespass. Let me just take a look at this. All right, you're charged with trespass after warning for sleeping under I-4 after you're being told not to. I do find probable cause that offense occurred. Would you like the public defender appointed?
Yes, sir. Could I resolve today too?
Absolutely. What, you want to plea?
Yes, sir. I'd like to plead if
All
I
right.
could today.
The victim's the city of Orlando, so I don't know if you would, I don't know if they're actually considered like a personal victim.
Well, that's up to him. I mean,
No, I was just saying
Yeah.
for like, I didn't want it to be like the last situation where
Yeah.
they plea and then they don't get to,
Okay.
you understand?
Yes. The charge against you is that you slept under I-4 at Amelia and Garland after you were told by law enforcement officers you were given a trespass warning on January 8th, 2019, not to go to that area, and then you were back there on May 24th, 2019. Do you understand that those are the facts that have been alleged in this?
Yes, sir, I do.
All right. And do you wish to enter a plea of guilt?
Yes, sir, I do.
Do you understand you have the right to an attorney or to have an attorney appointed to represent you in this case?
Yes, sir, I do.
All right, do you waive the right to have an attorney appointed?
Yes, yes.
Do you understand you have the right to trial by jury on this matter and to have a group of citizens decide whether you're guilty or not?
Yes, sir, I
And
do.
do you waive that as well?
Yes, sir, I do.
All right. I'm going to find that you've entered a voluntary and intelligent plea. If you are not a U.S. citizen, it's possible that this offense might result in your deportation. Do you understand that?
Yes, sir.
All right. I will accept your plea of guilty. I'm going to sentence you, here's what, 1 day, time served? What time? I'm just going to sentence him to time served. Huh? 2 days. 2 days. Okay, you're adjudicated guilty, sentenced to 2 days time served, and just find someplace else,
Yes, sir.
or maybe one of the shelters will have some room for you.
Thank you, sir.
Thank you.
Have a good weekend.
You too. All right. Okay, so what was this? Oh, this is the ones I'm going to. All right. And your name, sir?
Jamal Tapper.
All right, Mr. Tapper, you have been arrested on charge of possession of cannabis and possession of drug paraphernalia. I've examined the arrest affidavit, and I do find probable cause for both of those offenses. Would you like the public defender appointed?
No.
No? Okay, that's fine. Your bond on each of those charges, the first count is $100, the second count is $500. So you can be released on bond. I don't have my PTR sheets in any kind of order here. Is he eligible for PTR?
He is out on bond.
He's out on, oh, that's right, I have it right here.
It's an NTA for voting.
For no wake zone.
Bad timing.
I just, you're a John Dillinger, you know, around, sorry, can't take it seriously. I'm going to take no action on the no wake zone offense, and your bond will be stayed as indicated on, you know, yeah, the bonds will be stayed. Okay, so, there you go. Do you want the public defender appointed?
I have a lawyer. I just couldn't get in contact
Good.
with him.
Okay, well, he can represent you on that.
Appreciate you, boss.
You betcha. Make that boat go slow. No wakes.
No, I know, I'm gonna do it. I just had to look at your thing. We gotta wait for him to talk.
Okay. And your name?
I got you.
Catherine Todd.
All right, Ms. Todd, you have been arrested on 2 offenses. One is trespass in a dwelling, and the other is possession of drug paraphernalia. I have examined the arrest affidavit, and I find probable cause as to both. Do you wish to have the public defender appointed to represent you?
Yes.
All right, let's appoint the, well, I don't have information on you, so let me just ask you a few questions. Oh, you got some? Oh, okay. All right, based on your affidavit, I do find that you qualify. The public defender will be appointed. Your bond on the trespass charge is $500. Your bond on the possession of drug paraphernalia charge is $100.
Your Honor, we'd ask for ROR on both counts. She has 1 misdemeanor conviction for prostitution and no failures to appear. So we'd ask the court take that into consideration.
I do. The problem is that she has no address. So I don't know if we ROR her how we're going to be able to get any information to her. State want to be heard?
Yes, Your Honor, the state was gonna mention that, no community ties have been able to be established, so.
Yeah. That's, so I'm gonna leave the bond the way, if you had a regular place you lived, we might let you go because we know we'll be able to contact you there, but
She indicated that she was gonna go live in a hotel.
Can I have no FTAs.
I know, the problem is, if we let you go now, we have no way to contact you.
I have a cell phone.
Well, they don't call, they have to send you something.
Okay.
Yeah.
Can I use my mother-in-law's address?
No, because that's not where you're gonna be. The thing is, if we, I'll tell you what I'm gonna do. I'll make the bond on each count $100.
Okay.
So if someone come up with a couple $100, then you can get out. Because the reason we do that is because that way that person has a reason to go and find you. And we don't have to.
Okay.
All right?
Can I?
They're not gonna let you play because of the charge. Yes, because they're not gonna let you, because of the
Ma'am,
trespass.
you can talk to the lawyer later. It's getting
Okay,
late and I
thank
want to get these people
Thank you.
home before the crack of midnight. All right, what's your name, sir?
Gregory Carson.
Sorry?
Gregory Carson.
Curtis
All right.
Young is mental health, Your Honor.
Mental health. Okay, we'll see him tomorrow. Mr. Carson, you've been charged, you've been arrested on a warrant out of Seminole County. The bond on that warrant is no bond, so you will be held until you are transferred to that county. You also, there's two. There's two warrants out of Seminole County. Each of them has no bond, so you'll be held here until you're transferred to Seminole County to see the judge in those cases.
They'll pick you up in 72 hours.
Are you familiar with it?
No, he's not. That's Seminole County. This is Orange.
All right, next, sir.
John Cunningham?
Mr. Cunningham, you are, okay, you're here on an out-of-county warrant, two out-of-county warrants, for fraudulent use of credit card and burglary of conveyance. Those both have bonds set at $2,000. You also are here, just a moment, on, I'm sorry, you're on a lot of out-of-county warrants. The first two I said were $2,000 each. There are,
It's all one case. It just looks like it's several counts.
several, it's 44. Yeah, 43, I'm sorry. So you're being held on, the out-of-county warrant is on 43 counts of something, and the bond is $25,000 on, hold on, $25,000 on 1 through 20, and then $2,500 on 21 through 26. I'm sorry, 21 through 43. So you're going to be in jail until they send you to the county that issued the warrant, and then they'll deal with the judge there. Oh, is this him? Oh, I already did that one. That's the first one.
No information's been filed in that case, so don't take any action would be my, and it's been more than 33 days.
Yeah. No, we won't take any action on that now. All right. Your name? Please.
Tanis Kaiser.
Okay. You have been arrested on a warrant out of Seminole County for failure to appear at sentencing.
Yes, sir.
Your bond is set by the judge in that county at $660. And if you post bond, you can get out. And I
Okay.
think this is all, is this two things?
No, that's it.
One thing. Okay,
Thank you.
thank you. And yes, your name?
Danielle Moore.
Ms. Moore, you were also arrested on warrants out of Broward County. There's two counts. One is a bond of $1,000, the other is a bond of $100. So for $1,100, you can bond out. If not, you'll be taken to the other county to face those charges.
Okay.
Okay?
You can bond out. Okay.
All right. Okay, the next person I had was a Shakita Walker. Not on your docket, okay. Not over there. All right, sir. Tell me your name, please.
Ivan Villanueva.
Huh? Oh, did I read it wrong? Oh, okay. I've been up since 6:30, okay? All right. Y'all be cutting me some slack here. All right, so you've been arrested on a violation of probation. And the judge that issued the warrant for a violation of probation set the bond at no bond. So you'll be staying in jail until you see that judge.
Well, do I have to see the judge here or in Osceola County?
It's from Osceola? Osceola County. They'll be sending you down there. All right, sir? Yes, sir. What's your name?
Marvin Kemp. Marvin Kemp.
Marvin Kemp. Okay, what about Jonelle DeCavius, Jonelle Burton?
He refused, and also David Graham refused.
For Burton, can we waive his IA? He's already been adjudicated in competence proceeding, and I believe we represent him on the case that he's out on conditional release for. So we waive his IA.
That's fine. Waive the IA, the bond will, probable cause is found, the bond is stayed.
That was on Burton?
Yes.
Oh, he's already bonded on this case?
No, he's out on bond.
Oh,
What I was saying is that we represent him on that case where he's been adjudicated and competent to proceed on 12/12/2018, so I ask that you take no action.
I won't. No action. All right, Mr. Kemp, you are here on two violations of probation, one on possession of cocaine and one on, I'm sorry, there's more than that. Oh, there's a lot more than that. In CF 16-128, you're here in violation of probation for counts 1 and 2, possession of cocaine, possession of paraphernalia. In 17 CF 3936, VOP on delivery of cocaine and possession of cocaine. In 3935, VOP on delivery of cocaine and possession of cocaine. I'm starting to see a pattern here. In 2017, CF 3907, VOP on possession of cocaine. And in 2019 CF, is this a new case? Oh, a new case. Oh, good. So now you have a new case, which is sale and delivery of controlled substance. Just a moment. Sale and delivery of fentanyl. This is based on a warrant issued by a judge, and your bond in that matter is $7,500. Would you like the public defender appointed on your VOP cases and your new case?
No, I got a private attorney on my VOP cases.
All right,
Because what happened, I went to court.
Yeah.
For the fentanyl.
Go for it.
No, because what I'm saying, sir, is Thursday I went to court, outside court, for the VOPs, but they locked me up because they said I had a warrant for a selling delivery of fentanyl.
Right. But that may be a new violation of your probation.
Yeah, that's what they were saying because I violated for a charge, but the charge had got dismissed, so I was going to court to get reinstated back on probation.
When you get before the judges that have issued all these warrants.
Yeah, they set a court date already for June the 4th already for the judge.
Okay. Well, you'll be in jail till then.
Yeah,
All right.
I already know.
Okay, sounds good. That's Mr. Kemp. Okay. There's Mr. Poland.
We already addressed him.
I know. I just found another one on him. But I think this is the one we already did.
This is the one we couldn't find earlier, but we addressed both of them at the same time.
I thought so. Uttering the forger, I remember that. Yeah. All right, your name?
China Snyder.
Okay, just a minute. China Snyder. Okay, I had Donta Rucker.
He's mental health.
I'm sorry?
Mental health.
And Rasha Russell?
She's mental health also.
Mental health. Well, they're busy today. All right, Ms. Snyder, you have been arrested on a number of charges. Just a moment. Yes, you've been arrested on charges of possession of a firearm by a convicted felon, possession of ammunition by a person who committed a delinquent act, possession of cocaine within 1,000 feet of a place of worship with intent to sell, possession of methamphetamine with a weapon, sale and delivery of cocaine within 1,000 feet of a park, possession of drug paraphernalia, and possession of cocaine with intent to sell within 1,000 feet of a park. Would you like the public defender appointed to represent you in these cases?
Yes.
All right, based on your affidavit, the public defender will be appointed. Your bonds on the 7 counts are as follows. Count 1, $150. Count 2, $150. Count 3, $10,000. Count 4 is $10,000. Count 5 is $10,000. Count 6 is $100, and count 7 is $10,000. I guess, apparently Judge Carter, what does this say? State to provide supplemental complaint.
Yes, Judge, and I did receive here in the packet, supplemental affidavits, if I may approach.
Yes, please. Oh, okay. Oh, these are the return things. All right. Based on that, I find probable cause, and the bonds are set by Judge Carter.
Thank you, Your Honor.
All right? That's right, these are all returns. Didn't realize that. Okay. Please state your name.
Renisha Stoward.
Okay. This is another case where probable cause was not found, and the state attorney's office had 24 hours to supplement that. And this is a co-defendant of the other. It's the same affidavit?
I believe some of it is the same at least, but this is what.
Go ahead and hand it to me, and I think it's probably pretty much the same. Thank you. All right, based on the supplemental affidavit, I do find probable cause exists, and the bonds will be set as indicated on Judge Carter's order of commitment. $10,000 on count 1, which is possession of cocaine within 1,000 feet of a place of worship with intent to sell at $10,000. Possession of methamphetamine with a weapon is $3,500. Sale and delivery of cocaine within 1,000 feet of a park, $10,000. Possession of drug paraphernalia, $100. Possession of cocaine with intent to sell within 1,000 feet of a park is stated at $10,000. I don't think I've appointed the public defender yet, have I?
I don't remember.
Oh, they were appointed yesterday, so, okay,
Okay.
you've already been appointed. All right, the next one, your name, sir?
Tillman.
Mr. Tillman. This is another one, does the state have a supplemental affidavit?
I do, Your Honor. Absolutely.
Yes, you may. this is the same, okay.
I think they're coded.
Yeah, they are. All right. Court finds probable cause on this as well. The bonds are stayed as they were. Public defender has already been, has a public defender, or,
I don't know if it was appointed yesterday, but go ahead and appoint us, and if there's a
Alright.
conflict, we'll deal with that later.
public defender will be appointed in those matters. Your bonds, sir, on counts 1 through 4 are $150, count 5 is $10,000, and count 6 is $100, and count 7 is $150. Thank you. Okay. All right. Your name, sir?
William Brumfield, sir.
Mr. Brumfield, you have been arrested on a violation of probation warrant out of Orange County for violation of probation that we put on charges of possession of cannabis, the intent to sell and possession of drug paraphernalia. Your bond is set by the judge at no bond, where it will remain until you appear before the judge. You are also apparently on bond on carry and concealed firearm on 2019 CF 5170.
Yes, sir.
Any requests from either side on that one?
He's no bond on the VOP, right?
Right.
I don't.
I'll take no action.
Yeah, okay.
Okay, thank you, sir. You're all done. Your name, sir?
Jeffrey Smiley.
Mr. Smiley, you have been arrested on charges of possession of MDMA and possession of alprazolam. I've examined the arrest affidavit and find probable cause. Would you like the public defender to be appointed?
Yes, sir.
All right, based on your affidavit, you qualify, so I will appoint the officer of the public defender to represent you. The bonds on the 2 counts, count 1 is $1,000 and count 2 is $150. Those bonds will be stayed. Oh, you also have, sorry, a violation of probation, maybe a couple of them. 16 CF 6101, you have a warrant, warrant for violation of probation. Is this a warrant or on view? Hold on a second.
One is on view, one is
Okay, the one I just mentioned is an on-view arrest for violation of probation. I find probable cause exists in that affidavit, and your bond is set at no bond pending your meeting with the judge in that case. The other case is a warrant for violation of probation. In that case, the acts were aggravated stalking and criminal mischief. The bonds in those are no bond, and you'll be held pending those. If I haven't already asked you, because I'm getting bleary, would you like the public defender appointed on any new charges?
Yes, sir.
All right, public defender will be appointed to represent you on those charges. All right, Mr. Dempsey? Sir. All right, you've been arrested on, I'm sorry, your new charge is disorderly conduct. Just a moment. I don't find probable cause for disorderly conduct in this case. I'm on RR, the defendant. I don't really think that this can be fixed, so he'll be he's on ROR now for possession of amphetamine, but I'm not gonna take any action on that.
We appoint the public defender for this case?
Sure. You want the public defender appointed?
Yes, sir.
Done.
So I'm going home today, sir?
There you go.
Here, on this right now.
Thank you, sir.
You bet. All right, next. Who's up next? All right, so your name?
Larry Lucas.
All right, Mr. Lucas, you have been arrested for camping, prohibited exceptions. Give me just a moment. I do find probable cause from the affidavit that you violated the city ordinances against camping. According to this, you were out on bond on possession of methamphetamine and trespass on property after warning. Your bond on the camping is set at $250. Would you like the public defender appointed?
Yes, sir. Yes, sir.
Yes?
Yes, sir.
Okay. One question. Were you camping because you had no place else to? Never mind. I can't ask that. I'm sorry. I'm sorry. Do you have any income?
Yes, sir.
What income do you have?
Social Security and pension.
All right. How much is that a month?
How much do you get in Social Security?
I'm trying to count it up.
Oh,
But
okay.
seven something Social Security and about like 100 something in my pension.
And how much was the pension?
100 and something, about $60,
100 something for the
$160,
pension?
something like that.
All right. Do you have any other source of income?
No, sir.
You have any, you own any real estate,
No, sir.
jewelries, boats?
No, sir. I don't.
Cars?
No.
Okay. You won't be violating the no wake zone, will you? We had another guy in here. Anyway, okay, I'm going to appoint a public defender to represent you in this case. I am not going to take any action on the other cases he's on bond for. The bond on this case is $250.
We'd ask, this is a non-violent misdemeanor, and it's the state's non-monetary bond policy to advocate for ROR on charges like this, all city ordinances.
Ready? Advocate.
State has no objection to ROR.
Then ROR it will be. Boldly advocated. Boldly advocated.
Thank you, sir.
All right. Next. Sir, what's your name?
Michael Mason.
All right, Mr. Mason, you were picked up on a charge of panhandling. Let me look at the arrest affidavit very quickly. All right, I do find probable cause that that offense occurred.
Is your plea, sir?
You want to resolve it today? Yeah, sure.
Yes, sir.
Okay. Do you want to chat with the public defender real quickly?
Yeah. What is the plea?
I don't know, we have to ask the judge.
What is your plea?
Does he have 1 or 2 days?
Yes.
2 days.
An offer from the state would be credit time served for 2 days.
Thank you.
Okay. So, you want to sign the plea form?
Yes, sir.
Based on the arrest affidavit, we'll find sufficient evidence, and we'll accept the plea as freely and voluntarily made. Do you understand all the rights you're waiving on that piece of paper?
Yes, sir.
Any questions about any of them?
No, sir.
All right. Then I'm going to sentence you to time served,
Sir.
and good luck to you.
All right, thank you, sir.
All right. Are you Mr. Scalera?
Yes, sir.
All right. You have been charged with the offense, the heinous offense of camping. It's late, and I should make a joke, but I'm just too dang tired. I do find probable cause existed from the arrest affidavit for that offense. Would you like to have a public defender appointed?
Sir, I'm naive. I don't know how to answer that. I mean, I would hope to get ROL or ROR. whatever.
ROR?
I would
He's
hope so.
asking you if you want a lawyer. Do you want me to represent you today?
Could you represent me today?
I
Yeah,
can.
Yes.
Yeah. Okay, we'll
Yes.
appoint the public defender to represent you today. The only reason I can't ROR you is because we have no way to contact you. So we'd have no way to tell you when to get back. Do we have any information about his history?
Only 2 misdemeanor convictions.
Okay.
It's also the state's non-monetary bond policy to advocate for ROR in charges such as camping.
If we had any way to contact him, I would, but does he want to resolve the case right now?
That's up to him.
Well, you're his lawyer, you
Do you
talk
wanna
to him about
resolve
it.
Can you?
Yeah.
Yes.
How many days credit does he have? Would the court accept a credit time served offer?
Absolutely.
All right.
All right, sir. Look at that plea form. Now, understand that what you're doing is you're admitting that you broke the laws that violate, that prohibit camping.
Okay.
Okay? You
Yes,
understand
sir.
that?
Yes, sir.
Okay. And there's all kinds of rights on there that you're waiving, so make sure you understand that too.
Okay,
You
yes,
got
sir.
an attorney with you. All right?
Yeah.
All right, sir. Based on the evidence presented in the affidavit, I'm going to find that sufficient evidence exists for camping, and I'm going to find you guilty based on your plea and sentence you to time served. And going to have to find someplace else to sleep.
Yes, sir.
All right? All right. That's it.
Thank you, Your Honor.
Thank you.
Have a good day. Good luck to you.
Now, there's a little bit here. What is this? What is this? Okay. What is this? All right. Oh, that's that list. So I seem to only have one left for my imagining something, no? I have a Blacknell, Terrell, huh?
What kind of charge is it?
Possession of cocaine? Bonded, do you think? So are we done? Hallelujah, praise the Lord. I'm going off the record. Normal. This is orange. You know, I probably don't really need to. Hold on. Hold on. Okay. And the state's familiar with this?
I just received copies this morning, so I've reviewed that already.
Okay, and I see there's, okay, great. I saw the email.
An email correspondence
Yeah.
between the attorneys who were in Division 12.
All right, there you go. So you just want, you want the whole packet for her, just?
Yeah, she could take the whole packet. That was just for the court so that you knew we weren't trying to run one by you or something.
Probably gotten away with it.
What's that?
You've probably gotten away with it. I don't know. All right, so what are we doing first? Osceola. This one? Okay, oh. I would have checked my makeup if I didn't have on TV. Okay. Yeah, I'll just pass them off to you.
Okay. Great.
We'll just do it that way. There you go. Right. All right, good morning. We are here for initial appearances. The first case will be Mark Anthony Maldonado.
Alicia Smith on behalf of the Public Defender's Office, Judge. And after we do Maldonado, the deputies asked if we can do Dixon next.
Sure. Mr. Maldonado, good morning. You have been, you're in custody on a violation of probation warrant. Your bond is presently at no bond. I believe you have is the public defender already appointed in this case?
No, Judge, he asked for the Public Defender though.
All right, do you want to have a public defender appointed, sir? Can you hear me? I can't hear him at all.
Yes, sir.
Okay. Then the court will appoint the public defender. Do we have a hearing date for him, or he'll be noticed? Okay. Anything else from the public defender?
No, Judge.
Or state?
No,
All right. Thank you. And what was the one you wanted me to call next again?
Dixon, Valerie Dixon.
Valerie Dixon. A second. Okay. Okay. All right, Valerie Dixon. Trespass after warning. Good morning, Ms. Dixon. You've been charged with the crime of trespass after warning. I've examined the affidavit. I do find there's probable cause for detention. Your bond is set at $500. You do qualify for pretrial release. So the court will, pass the order along. There we go, getting it right. The court will grant pretrial release, and you will be given notice of future court dates and arraignment. Would you like the public defender to be appointed?
Oh, no.
I couldn't hear you.
No, sir.
No.
No.
All right.
No, yeah. She said no, Judge, it's just a delay.
Okay, that's all right, I got it. All right, anything else?
No, Judge.
From either party? No? All right. That will conclude that case. Yes.
This is Margaret Jones with PTR.
Yes,
I was wondering
I do.
if Ms. Dixon could have a mental health evaluation and maybe mental health conditions of PTR.
Does the public defender want to have any input on that?
Judge, you just asked for straight PTR in this case without the mental health condition.
Well, based on what I read, I think the mental health evaluation is probably a good thing. And whatever assistance it can give to her. So the court will order a mental health evaluation as part of the pretrial release. Thank you. Do I just pass this off to you? Okay. All right. Let's call Brian Michael Zushin. There's a number of matters. Good morning. Just take me a moment here. There we go. All right. You are here on a number of matters. The first is charges of possession of marijuana under 20 grams and possession and use of drug paraphernalia. I do find probable cause for count 1, possession of marijuana under 20 grams. I do not find a probable cause for possession or use of drug paraphernalia. The arrest affidavit does not mention any items of paraphernalia that were found. The bond on count 1 is presently set at $500. You do qualify for pretrial release. We'll wait till we get to the end to determine that, but you will get, let me start over. You will be given PTR as to this case. All right. Okay? Huh? Oh, I'm doing this one? I did the possession of paraphernalia and cocaine first. Oh, I'm sorry, I didn't give them all to you. There you go. I had them all separated out and didn't give them to you. Okay, so that's the... Got those in the right order? Okay. So PTR, PC's found, PTR on that one.
Okay.
And I don't think I signed it.
I'm sorry, Judge. You said
And no PC on count 2. That's correct. Yeah. And I need to sign it. I didn't sign those orders. Sign them later? Okay. All right. So that is that case. The next case is charge of driving under the influence of alcohol or drugs, first offense. I've examined the arrest affidavit. I do find probable cause on that case as well. The bond is set at $500. The court will put this case on PTR as well. And we'll address the public defender at the end of all of these cases. All right? You got that one? All right. The next case is resisting without violence. I have examined the arrest affidavit, and I do find probable cause for that charge. The bond was set at $500. The court sets release at PTR. Oh, there's one that got missed. That's this one. The next case is a charge of fleeing and eluding high speed with disregard of public safety and reckless driving. I've examined the arrest affidavit, and I do find probable cause for those charges. The bonds are presently set at $500, and the court sets release at PTR. All right. The next one is fleeing and eluding high speed with disregard of public safety. The court has examined the arrest affidavit and finds probable cause. The court will set, the bond is presently set at 0. Court will set PTR as release for this case. The next case, the last case, is a charge of misdemeanor stalking. The court has examined the arrest affidavit and does find probable cause for that charge. The court will stay the bond at $1,000 on that case, and there will not be PTR on that case. Special condition in that case is that, sir, you are to have no contact of any kind with the victim in that case. I want to make very clear to you what that means. It means you do not contact her. It means you do not call her, text her. You do not reach out through social media. You do not try to attract her attention through social media. You do not have a friend reach out to her. You do not contact her in any way. And that also includes you should not come within 500 feet of her place of residence or 100 feet of her vehicle should you see her in a vehicle. Do you understand that, sir?
Judge, I did want to make a
Okay.
argument as to the stalking charge.
Yes.
On the police report,
Go ahead.
there's no indication of any verification in terms of the multiple pages that the alleged victim indicated were made. The only incident in terms of physical presence was when they were in the same location at which he left, which they both vacated. There's nothing in the police report to indicate that the police looked at either of the pages that she indicates that he made, or that they were able to verify that he was the maker of those pages. So I didn't know that I didn't think there was probable cause for stalking since they were both in a mutual location, aside from the multiple pages they were supposedly made.
Well, I think what the court found was that the acts contained in this affidavit on that day, combined with the prior acts of creating the fake pages on social media and attempting to contact her, are multiple acts that would constitute stalking taken as a whole. That is probable cause there is that they would constitute stalking.
Okay.
Thank you, counsel. Now, sir, would you like to have the public defender appointed to represent you temporarily in these charges? Was that a yes? Okay. Then the public defender will be appointed to represent the defendant in all these charges.
Thank you, Judge.
You're all caught up? You're good? Okay. There's the next one. You know what? We'll sign them later, you said, right? Okay. The next case is Rafael Santiago Porcino.
He's at the hospital, Judge. Can we reset him for tomorrow?
Yes. So that'll be reset for tomorrow. Okay. Carmelo Jesus Rosario Huey.
He needs the interpreter, Judge. Do you have an interpreter?
Talia Romero, Spanish interpreter, for the record.
Okay. Will you have a Spanish interpreter? Sir, you have been arrested on charges of dealing in stolen property, false verification of ownership information in a pawn transaction, and petty theft.
Señor, usted ha sido acusado de haber estado negociando con mercancía robada, haber provisto información falsa a una casa de empeño, hurto menor como un primer delito también.
I've read the arrest affidavit and find probable cause as to all three charges.
Yo he leído la affidavit acusatoria y he hallado que hay causas que respaldan la acusación en los tres cargos.
Does the public defender or state attorney want to be heard on the conditions of release?
¿El fiscal o el defensor público quieren decir algo en cuanto a las condiciones de libertad?
Your Honor, may I ask PTR what the history is?
La fiscal está preguntando cuál es el
It
historial.
appears that he is on supervised state probation for case 2019 CF 706, petty theft, 2 priors. That's what it says on the initial appearance information sheet.
Aparentemente está en libertad vigilada o probatoria por un caso y por otros 2 casos de hurto menor.
Your Honor, I also have some other criminal history, if you would like to hear that.
Yes, go ahead.
Okay. Since 2009, he's had 11 convictions, and that includes a battery, trespass, a cocaine charge, 4 larcenies, including the one that he's on state probation for, the petty theft, with 2 priors.
Do we know if a violation of probation has been filed on the other case?
No, we do not know
Se está
that yet.
comentando que usted tiene un historial desde el 2009 con 11 condenas, unos por casos de agresión, entrada ilegal, tenencia de cocaína, 4 por hurto menor, incluyendo los 2 por los cuales está en probatoria vigilada o libertad vigilada. Actualmente, el juez ha preguntado si ya se ha formulado una orden de arresto en el caso de incumplimiento de probatoria. Aparentemente no.
Sir, would you like the public defender appointed to represent you temporarily?
Señor, ¿usted quiere que se le designe el defensor público para que le represente temporariamente?
Lo que pasa es que yo no tengo. I don't have any charge. Yes.
All right. Court will appoint the public defender temporarily. Does the public defender have any comments about the bond?
Se le designa el defensor público temporariamente y el defensor público tiene comentarios que hacer en cuanto a la fianza.
I just asked the bond to be set, I believe per the warrant, the bond was set at $2,800 total, so I asked that bond be remained and no action as to any alleged or potential violation of probation. This is a warrant case, and I'm unable to verify if this would have predated the probation sentence or not.
All right. Then the
Estoy
court
pidiendo que se le dé
will
la-
stay the bond as established previously.
El juez va a determinar que la fianza es la misma que previamente se había predeterminado.
All right, thank you, sir.
Gracias, señor. Eso es todo. La misma fianza. Same bond.
All right, next case is Javier Rivera Pagan. Sir, would you please state your name?
Javier Rivera Pagan.
Sir, do you need the services of the interpreter?
¿Usted necesita los servicios del intérprete, señor?
No? Okay. You've been arrested on charges of possession of controlled substance without a prescription and possession or use of drug paraphernalia. The court has examined the arrest affidavit and does find probable cause for both charges. Your bonds were originally set at $2,500 and $500. You qualify for pretrial release, so the court will permit you to pretrial release. Anything further from the state or defense?
Nothing from the state.
He was deemed not indigent.
This is the first time I've done IAs, folks, so I'm relying on all of you to let me know if I forget anything.
No, Judge, he was deemed not indigent by the clerk, so I don't believe he will be appointed.
Yes, I have called that. Thank you.
Your Honor, this is PTR.
Yes.
I would suggest that he have
Yes.
random drug screens.
Oh, excellent suggestion. So we'll add random drug screens to the PTR. All right, Mr. Daniel Ramdas. Sir, you've been arrested on a violation of probation community control warrant. That warrant indicates that your bond is no bond. Court will stay the bond as no bond until you see the judge who will hear your VOP. Would you like the public defender temporarily appointed to represent you? All right, the court will appoint the public defender to represent the defendant. Oh, there's the order. I'm still working on this process here. Okay, here's that guy. All right, next case is Chad Perry. Please state your name, sir.
Chad Perry.
All right, Mr. Perry, you have been arrested on warrant, warrant for violation of probation out of Osceola County. Your bond is presently set at none. The no bond will be stayed until such time as you see the judge that issued the warrant for your arrest. Would you like a public defender appointed for you in the interim?
Yes, sir.
All right. Court will appoint a public defender temporarily to represent the defendant. There you go. Okay. Mr. Henri Josette,
He bonded.
or Jose?
He bonded.
He bonded, okay. All right, there you go. Victoria Rosina George. Would you please tell me your name?
Victoria George.
Hi, Ms. George. You were arrested on a warrant, a VOP warrant, out of Broward County, Florida. The warrant dictated that you should be held without bond and transported back to Broward County to face those charges. You will be held without bond pending resolution of this matter. Would you like the public defender appointed for any matter that may happen here in Orange County? All right, we'll appoint the public defender temporarily. Thank you. All right, the next case is Amanda Freeman. Would you please tell me your name?
Amanda Freeman.
All right, Ms. Freeman, you have been arrested on a charge of simple battery. I've examined the arrest affidavit, and I do find probable cause for that offense. Your bond is presently set, what is your present bond? None. You're being held without bond at the time. You qualify for PTR. The suggestion is bond with PTR. Someone please define that for me.
Judge, I'd ask.
So that's a monetary bond?
Yes, Judge, it's bond with condition of pretrial release. I asked for either straight PTR or a monetary bond, not both conditions, Judge.
All right. State want to be heard?
State would have no objection to straight PTR.
All right. Our PTR folks, do you want to be heard on this?
Yes, Your Honor, she does not qualify for straight PTR. She only qualifies for a bond with PTR due to her prior.
Right. Oh, I see. 7 prior battery arrests out of Georgia. So the court, sorry?
Sorry, she also has an outstanding warrant in Georgia with no
Oh, I see that. Okay. Well, the court will not put on PTR alone, but we will set a bond. Would the state or defense like to be heard on the amount of the bond?
Judge, I'd ask for a $500 bond in this case. Ms. Freeman is pregnant. She's actually scheduled to be induced this coming Monday. So she needs to be released. Well, we're asking for her to be released so she can go out and give birth in a safe environment due to being pregnant at this point. So we'd ask for a $500 bond in this case. In terms of additional release conditions, it's my understanding that the alleged victim, her brother, doesn't reside there. He was only there visiting. Pretrial release hasn't been able to make contact with him, but she resides there with her mother, so I would ask for her to be able to return home as well.
Does the state want to be heard?
Your Honor, based on her condition of being pregnant, the state has no objection to setting a monetary bond. I think the PD requested $500. Just even if they maintain separate residences, the state would request a no hostile contact order and
All right.
such to be placed.
The court will set the bond at $500. The condition of bond will be that you have no hostile contact with the victim in this case. That means that you are not to get into any kind of argument with him. That means if he tries to start an argument with you, it is your obligation to leave. He will not get in trouble for getting in a fight with you, but you will. So if he tries to start trouble with you, you go the other way. If he comes to the house, you go sit in the bedroom by yourself. You understand that?
Yes, sir. Sir, is it able to, I could get a restraining order or something? I don't want that contact.
Yeah, we can't do that. You'd have to file for that in the Osceola County Courthouse, but I can't do that today. All right? Thank you. Oh, yes. Would you like the public defender appointed temporarily to represent you?
That's fine, yes, sir.
All right. Public defender will be appointed temporarily. Thank you. That's all. You can go have a seat. Okay, Michael Anthony Fabiani. Please tell me your name, sir.
Anthony Fabiani.
All right, Mr. Fabiani, you are charged with battery. I believe this is a domestic violence battery on your ex-wife. The court has examined the arrest affidavit. The court does find probable cause for that charge. You're presently being held at no bond. Would the state or defense, well, first of all, sir, would you like the court to appoint the public defender to represent you temporarily?
Yes, sir.
All right. The court will appoint the public defender to represent you temporarily. Does the state or defense want to be heard on the issue of bond?
Judge, I asked for straight pretrial
Your
release
Honor,
in this case. I'm sorry, State.
may we hear from PTR if there's any
Yes.
history?
Well, PTR, go ahead and tell us. I have your recommendation that he does qualify.
Yes.
But go ahead.
Yes, Your Honor. Prior to this case, in 1996, he had a burglary with assault, carry a concealed weapon, and trespass, and those were adjudication was no. He had a 2-year probation for grand theft in 1992, and in 2008, a battery which was dropped. 2014, he had a sexual assault that was dropped, and a violation of a domestic injunction that he did receive 1-year probation.
So he has a prior conviction for violating a domestic violence injunction?
Yes, sir.
Okay. State, you want to be heard on this?
And PTR, he qualifies for PTR?
That's what
Is
it
that
says, yeah.
Yes, ma'am.
Your Honor, based on the history, the state would request a monetary bond to be set.
Yeah, the court will set a monetary bond based on the prior history. Does either side want to be heard on the amount of the bond?
I'd ask for a $500 bond, Judge, since he does qualify for PTR as a lower moderate.
Your Honor, again, based on the history, the state would request a $1,000 bond.
Yeah, I'm going to set the bond at $1,000. The conditions of release is that you are to have absolutely no contact with the victim in this case. That means you cannot call, you cannot write, you cannot text, you cannot email, you cannot communicate with her in any way. The only person who is permitted to communicate with her on your behalf is your attorney. You are not to have any other human being on earth contact her for any reason on your behalf. You're not to go back to the residence where she lives. You're not to be within 500 feet of it. You're not to be within 100 feet of any vehicle that she's in. Do you understand these conditions, sir? All right. Will that be the ruling of the court? Okay, let me, you're right, I did put that down.
Okay.
A couple other conditions, sir, Mr. Fabiani, I also added, yeah, thank you, sir, I'm sorry, I'd forgotten about this. Were you living at the same residence?
My understanding, Judge, is they live together and work together within the residence, so yes.
We have our company.
Okay.
We all work together.
All right, so you're not to return to the residence. You're going to have to get a separate residence, and you may return to the residence one time with law enforcement to retrieve your personal items, any items essential for work. What kind of work do you do out of the house?
We do property appraisals and PI.
Property appraisals.
I'm sorry, what?
Property appraisals and PI.
Property appraisals? Okay, well, you're going to have to do that from another location until this matter is resolved. Anything else from either counsel?
No, Judge.
No, Judge.
Or from the clerk? Nope, we got it? All right, good to go. Thank you, sir. Okay, Ashley Ann Emmond. All right, ma'am, you have been arrested for a violation of probation. It was an on-site arrest based upon a failure to pass a drug test. You're presently being held at no bond, is that correct? Being held on no bond pending your appearance before the judge who is monitoring your probation. Does the other counsel want to be heard on the subject of bond?
If the court is inclined to grant a bond, in this case, Judge, you ask for a $1,500 bond.
State?
The state would request that the bond stay at 0 until she is present before the judge handling her case.
The court will set a bond in this matter because this was a drug screen failure, not a separate new crime. So the court will set a $1,500 bond in the matter. Thank you.
Public defender appointed.
Oh, yes, I'm sorry. Ma'am, would you like the public defender appointed for you temporarily until you see the judge?
Yes, sir.
All right, the court will appoint the public defender. All right, next case is Richard Delgado George.
Good morning, Your Honor.
Good morning. What's your name, sir?
Ricardo Delgado George.
All right, sir, you have been arrested on a charge of battery. And I do believe this is a domestic violence case. I've read the arrest affidavit. I do find probable cause. Would you like the public defender temporarily appointed to represent you?
He's going to hire a private judge.
All right. and the court will not appoint the public defender at this time. The present bond is set at no bond. Would the state or the defendant like to address the issue of bond?
May we hear the history from PTR?
Yeah, PTR, could you give us a little background?
Yes, sir. In 2008, he had a possession of marijuana with intent, a battery domestic, possession of paraphernalia, flee and elude, and then careless driving. He also had a VOP. He served a prison term from selling marijuana in August of 2013. In 2014, he had a possession of marijuana, paraphernalia conviction. He had 6 months probation. 2016, he had a possession of marijuana, destroying evidence, and passing counterfeit, and that was dropped. He also has he had conviction in Louisiana and Maryland. Maryland, he was placed on probation for that, and he's on federal probation right now. Expires January the 3rd, 2021 for illegal use of a credit card.
All right, sir, you want to tell me anything about your financial situation before I decide on the monetary bond?
I'll make the argument, Judge.
He didn't want you appointed, so you can't. Huh?
Sir,
No, I mean, he said, I'm sorry, just let me clarify one thing. Hold on. I thought he said he did not want the public defender.
Right, for initial appearance.
Or did I not ask him?
You did ask the judge. You said he was going to hire him for initial appearance purposes. I was going to appear on his behalf.
All right, sir, do you want the public defender to appear on your behalf for purposes of this hearing?
Yes, sir.
Okay, then go ahead, ma'am.
Judge, I asked that a bond be set in this case of no more than $1,500. While I understand pretrial release has read his history, there's no indication that there's been any on-due violation or that federal probation has been violated in any way. So I'd ask that he be given a bond in this case of no more than $1,500.
State?
Yes, Your Honor, the state has no objection to setting a monetary bond, though the state would request that it be higher than that, considering his history, as well as the history that he has in other states. That's all.
Sir? Sir, do you own any real property, like houses, land, anything like that?
No, sir. I have a vehicle in my name. That's it.
Okay, what kind of vehicle do you have?
An Audi,
What year?
2011.
All right. Do you have any bank accounts?
Yes, sir. I'm employed.
All right, where do
too.
you
I
have
work-
bank accounts?
I have a bank account with Wells
Where
Fargo.
do you work?
I have a bank account with Wells
Okay.
Fargo. I work at the airport for Swissport. I'm contracted through Spirit Airlines, sir.
Okay. How much money do you have in the bank?
Probably about, I want to say at least $500 if anything. You know, I make payments on my credit
Okay.
card and stuff like that. So.
Do you have any rich relatives?
I have family that, I mean, if needed to ask them for a lend of money, yes, that is possible, sir.
Okay, are these people that are local?
Yes, family members.
How long have you lived in Osceola County?
I lived in Osceola County for since 2008, sir.
Where'd you live before that?
I lived in Maryland. Prior to that, sir.
All right. Go ahead. Prior to that, where'd you live?
I was born in New York, lived in Maryland, I live in Florida, sir. This is where I reside at. My kids live
All
down
right.
here. All my kids, my two older kids go to the same school, which is not even 10 minutes away from my house, sir. So.
All right. Well, because the defendant is on, I guess, multiple probations, federal and state, if I heard that right.
It's just one judge. It's just the federal.
Just federal? All right. Because you're on federal probation and these events would violate that probation if you were convicted of them, I'm going to set the bond at $5,000. I want you to have a big stake in this game because we need to make sure you come back for court. So it's going to be $5,000. If you are released on that bond, you'll have absolutely no contact of any kind with the victim in this case. It means you're not to talk to her, not to text her, not to write her a note, not to ask your friends to talk to her. No one is allowed to talk to her on your behalf at all. The only person that can speak with her is if you get an attorney, if you hire an attorney, that attorney is allowed to speak with her. But aside from that, no one else can. You're not to return to the location where this occurred. Any other conditions that the state would like me to impose?
Maintain separate residences, Your Honor, if they don't
Maintain
already.
separate residences, that's correct. I think they already do, but don't remember. Yeah, maintain separate, anything else?
Judge, instead of the no return, can we just have them maintain separate residence? My understanding is that it's his mother's residence, so she, the alleged victim, doesn't actually live there, that she's in the process of moving. So we can have them maintain separate residence if she has in fact vacated.
Well, if she has vacated, he is not to go to her residence, wherever that is. If she vacates the mother's residence, then he can go back there. But he is not to go into any residence where she is.
Okay, so no
We'll make it even that broad.
And maintain separate residence.
No contact. He cannot enter any residence that she occupies, even temporarily.
Okay.
All right, anything else from the state?
Nothing, Judge.
Anything from the defense?
No, Judge.
Thank you.
All
Your
right,
Honor.
then that'll conclude this case. All right. I think this is our last one. Julian Lynn Bliss. Please state your name. All right, Ms. Bliss, you have been picked up on a warrant for violation of probation issued by the judge with jurisdiction over your case. The bond was set at none. That bond, no bond, will be continued, subject to your appearing before the trial judge. Would you like the public defender appointed in the interim? All right, court will appoint the public defender temporarily to represent the defendant. Next, you'll be notified of your next hearing date before the court. Anything from the state or defense?
Nothing from the state.
All right, then that concludes I believe that concludes all of our Osceola County cases.
Yes, Judge.
Anybody care to dissent that?
Nope.
All right, thank you very much, folks.
See you tomorrow.
That was the one that bond. All right, so, these Spanish cases, right, interpreter cases. All right, so we have cases requiring the use of our interpreter. So we, I'm sorry, what?
BCR. Switch over to BCR.
Oh, BCR? BRC?
BRC, sorry.
Okay. All right, so now we're over to BRC.
You need to put their names on the record
Okay,
for the court reporter.
right. They bring him in here, right?
Huh?
They're coming live, they're not on video.
Yeah.
Okay. So the first case we're going to call, well, let's see who we have here. What's your name, sir?
Eric Texidor Rosario.
I don't think that microphone's working very well. I can't hear anything.
Eric Texidor Rosario.
Okay.
Texidor Rosario.
All right, there it is. All right. Mr. Rosario, you have been arrested on charges of possession of firearm by a convicted felon and possession of ammunition by a convicted felon. I'm sorry, these were These were warrants issued by a judge. The bond in those matters are set at $4,000 for possession of firearm by convicted felon and $150 for possession of ammunition by convicted felon. Those bonds will be stayed. Would you like the public defender appointed temporarily?
Yes.
Right, the court will appoint the public defender temporarily for purposes of representing the defendant. There you go.
Thank you, that's all.
All right, anything else from the State of Defense?
No, Your Honor.
All right, thank you, sir.
Thank you very much.
Please state your name, sir.
Felipe Arujo de Lima.
Felipe Arujo de Lima.
All right. Sir, you have been arrested on a out-of-county warrant for a charge of stalking. The judge who issued the warrant indicated that you should be held on no bond pending your transfer to that county. Would you like the public defender appointed to represent you temporarily?
Yo tengo un abogado neste caso. Necesito, posso depois que yo tengo uno.
I do have an attorney in this case.
You do?
Do I need one?
I believe not.
What county is the warrant from?
¿De qué condado?
It's Osceola, it appears.
Este condado de Osceola.
I'll look it up.
Yeah, it appears to be Osceola.
And Your Honor, for the record, I believe this defendant speaks Portuguese versus Spanish. I was able to understand him, but maybe for the future paperwork, it needs to say that he's a
Portuguese?
interpreter.
Sí.
All right. So you'll be going to Osceola County to see the judge.
Ahora. Ahora?
Now?
How's the process?
Well, I'm not taking you in my car.
No lo voy a llevar en mi carro.
That's,
Sorry, because it's my first time. It's
I
new.
understand. I don't know exactly.
I don't know nothing about this case. I'm not out to the country. I don't know what's happening.
I understand. I don't know what this transportation schedule is, but as soon as they can. 24 hours?
Okay.
What they said.
Okay.
Thank you, sir.
Gracias.
Thank you.
So we're not going to appoint the public defender at this time. We've got an attorney down there. I thought we had one more. No? So Candido bonded? Okay. Have I reviewed these on? Oh, okay. I have reviewed this one. I did, yeah. All right, Mr. Barber.
Good morning, Your Honor.
Good morning. Sir, could you please tell me your name?
Christopher Shazani.
All right. Sir, you have been arrested on a charge of battery, which is the domestic violence case. I've examined the arrest affidavit. I do find probable cause for the charge. Presently, you're being held on no bond. Would counsel like to be heard on the subject of bond?
Yes, Your Honor. He has no prior history at all. He's not a flight risk, Your Honor. He presents no danger to community. We'd ask that he be released on his own recognizance, or if the court's not willing to do that, we would ask for a monetary bond of $500, maybe up towards of the maximum of $1,000. I know it came in as domestic violence. Based on the four corners of the arrest affidavit, it does state in there that they did not reside together, so it wouldn't actually properly be categorized as domestic violence, which we think would make it more appropriate for release on his own recognizance, Your Honor. Additionally, he was the sole occupant of that residence. The alleged victim does not reside there, so there are no issues about cohabitation, and so we just want to make sure he can go back to his own home.
All right. I did not get that impression from the arrest affidavit that they did not live together. Where is that?
If Your Honor looks on the first page, it goes 1, 2, 3, that fourth paragraph in the middle, the bigger one, the second line does state that they went back to his place, which indicates that it's
You're
not
right.
hers.
You're right. Okay, thank you. Anything from the state?
Your Honor, just letting you know that the state has already started a process to transfer this to the governor's office, so any way Your Honor would like to handle this.
The governor's assignment, yeah, I figured that was what was going to happen.
Yes.
All right. The court will, in this case, grant ROR. There is no prior history. The conditions of ROR are that you can have no contact of any kind with the victim in this case. No calls, no phone messages, no gifts, no cards, no reaching out through social media, no putting posts on social media to attract her attention, literally no contact of any kind. The only person that can contact her on your behalf is your attorney, Mr. Barber. Nobody else. Understand?
Yes, sir.
All right. All right.
Thank you very much, Your Honor. Have a great weekend.
You too. Thank you.
Does that mean all my battery TVs are getting ROR?
They have his background, yeah. Oh. It does look like it's a dating case, though, not a domestic case.
Yeah, I work in the DV division, and usually they come in as domestic, and then they transfer them out when they figure out it's not.
Yeah. Sure, let's do these. Yep, love it. Great idea. Okay, so we've got a few here that I have reviewed, so let's go ahead and call them. Joseph Murillo. I've also completed examining Stephen Polin, Carlos Torres Cardona, and Mandel Stewart. If anybody wants to have those, I don't know how you work back there, but if you have them in the bullpen. Just trap them between those two doors. It'll be perfect. In case you all wonder why I said that, I got trapped for 20 minutes between two doors in courtroom 3 when I was trying to find people. I had to call the comm center and have them call the corrections. Yeah. My card let me in.
But it didn't let you go through the next door?
But no, I got through both. Into the courtroom, and then as I was going back out, it stopped letting me. With my card. I came up the elevator that's right off the parking lot, the and I was walking around the back, you know, just I looked in here, I looked in there. Boy, I sure did. But it reassures me how secure this place is. Even judges can't get out.
Sorry, miss. Yeah, thank you.
All right. I'll do the rest of those in just a minute. All right, sir, please tell me your name.
My name is Joseph Murillo.
All right, Mr. Murillo, you have been arrested on a charge of domestic violence battery involving your daughter. I have found probable cause on that charge. Presently, you're being held on no bond. You don't qualify for the public defender, so you'll need to hire your own attorney. Does the state want to be heard on the subject of bond in this case? This is a father-daughter situation.
Yes, Your Honor. I also see that he's got no history in the state of Florida or elsewhere, so
All right.
the state has no position.
Sir, who are you?
May I say something, sir?
Yes, sir.
I have no criminal history.
You don't?
And I was in the Army in the past. I'm a vet. Honorably discharged.
It's my intention to release you on your recognizance.
Thank you.
But I just want to get an idea of sort of, generally in these circumstances, we try to separate the two people involved, but this is your
My
daughter.
daughter lives with her mother.
She lives with her mother?
Yes, we're separated. Her mother and I are separated. We're still married, but we're separated.
That's what I was going to ask you. So you're not the primary residential parent for your daughter?
Negative, sir. No.
Okay. Well, for the time being, part of your ROR is going to be that you not have any contact with your daughter until you get before the judge that's going to handle your case.
I understand.
And then we'll see what he wants to do, he or she wants to do about that. So ROR, only condition is no contact with the victim and maintain separate residences, which you already do.
Thank you.
All right, thank you, sir. Okay.
Thanks, miss.
Oh, those are all signed. Great. Oh, thank you. There you go. All right, sir, what is your name?
My name is Stephen Poland, sir.
Okay, Stephen Poland. Yes, sir. You have been arrested on two charges. One is burglary of a conveyance, and the other is grand theft. Let me just review this real quickly. Well, as to the burglary of a conveyance, I'm having some difficulty with the probable cause on that because it doesn't, the paragraph really doesn't tell me much of anything. Yeah, I mean, it doesn't say anything about how these cards were obtained, so I don't find PC on burglary of a conveyance. As to count 2, I don't find PC that it's grand theft because there's no indication of the value of the items stolen. Does the state want 24 hours to try and repair this?
Yes, please, Your Honor.
All right. All right, the state will, yes.
I was just going to tell him what you were doing.
Okay.
I would say
So,
I'll object for the record, but.
Of course.
Yeah.
What's happening here, sir, is that the information in your arrest affidavit is very, very sparse. It doesn't have enough information to establish probable cause that you committed the crimes charged. The law allows the court to give the state 24 hours to contact the police and ask them to supplement this affidavit, which, you know, it's one of the lazier affidavits I've ever seen. We'll see you back here tomorrow. If the state does not supplement the affidavit with enough information, then I will find no probable cause and you'll be released on your own recognizance.
Thank you, sir.
Understand?
Yes, sir. Thank you.
Before you go, do you want the public defender appointed to represent you during this interim period?
Yes, yes, ma'am.
That's
Sir.
her. Well, it may not be her, but
Yes, sir.
it's this tall, bald guy with a big gray beard. He's
Thank you, sir.
defender.
Thank you.
Come on, it's funny. Anyway, so we're going to appoint the public defender to represent you. We'll probably see you tomorrow.
You took my only PC challenge away from me.
Sorry?
You did my only PC challenge.
See, I was way ahead of you. Okay, next, sir, what is your name?
Mendel Stewart.
Okay. Okay, Mr. Stewart.
It's a refusal, Your Honor.
Torres refused.
I'm sorry, refuse what?
He's refused.
Torres Cardona. The one who's before.
Oh,
Mr. Stewart.
Torres Cardona has refused to come?
Yeah,
Yes.
so just reset him for tomorrow.
Okay, all right, we'll reset Mr. Torres Cardona for tomorrow. Mr. Stewart, you have been arrested on charges of burglary, conveyance, resisting officer without, 2 counts of resisting officer without violence as to 2 separate officers. I do find probable cause for all of those charges. At present, your bond is set at $3,500 on the burglary of a conveyance, $100 on resisting without violence on each count. Would you like the public defender appointed to represent you temporarily?
Oh, yes, sir.
All right, then court will appoint the public defender to represent you temporarily. I see that you have you have signed the advice of rights. Very good. Would either counsel like to be heard on the subject of bond?
Your Honor, just based on the history that I have here, it includes similar charges, so the state would request that the bonds be stayed.
Anything?
Nothing from the defense.
Okay, so bonds will be stayed. Oh, wait, I'm sorry, there's 2, I apologize, there's 2 separate cases here, my mistake. The second case is you're charged with violation of probation on 3 different charges: carrying a concealed weapon by a convicted delinquent, possession of a firearm by a person found to have committed a delinquent act, and possession of burglary tools. Basically, what they're saying is that based on the allegations in the first case, those would be violations of your probation in the other case. Would you like the public defender appointed on that case as well? All right, we'll appoint the public defender on that case. The bond on these matters is no bond, and based on what I've read, I'm going to stay the bond at no bond until you see the judge on the VOP.
Is that juvenile probation or is that
Good point. No, it's felony probation.
Okay,
Yeah, it's 2015 CF 8560.
thank you.
All right? Good luck to you, sir. So that's those 2. I'm sorry? Oh, the move-ups. Okay. All right. Take a quick gander and... All right, let's bring in Victoria Kwane Smalls. Yeah, I'm just going to review them as they're bringing them in. Yeah, I'm usually pretty quick. that in here.
This is Mr. Pullen. Why did?
I'm sorry?
They just brought me back, Your Honor.
Oh,
He had another case.
oh,
He's in two different spots.
okay.
But,
Oh. Well, apparently you had a second case that I didn't realize, and if I have it here, I can, is it in this? It's not in this stack.
they pulled it out, let me just.
I'm just going to read it real quick and see if we can get you done.
Is it the uttering the forged check? Is that what you're looking at?
Yeah, that's what I'm
Okay, I
about to
haven't
look
seen
at.
that affidavit. I thought that was part of the other one.
No, no. They got separated. He's on bond on that case? Okay, all right. All right, just a minute. Ah, okay, well, that fills in some of that. All right, so I've examined the arrest affidavit. In this case, you are charged with uttering a forged check. I do find probable cause for that offense, which is considerably more thorough than the last one. So I find probable cause for that. You are being held on $1,000 bond on that case. Would you like the public defender appointed for you temporarily?
Yes, sir.
All right, then we shall do that. Your bond at this point, unless either counsel would like to be heard about it, would be stayed at $1,000.
Nothing for this.
All right. All right, sir. And that concludes that. Is this something I have to do something with? Yes. Hold on a second. Okay, you're presently on bond on a possession of oxycodone case.
May I be heard on that?
You may.
Your Honor, it's been over, no information's been filed in that case. It's been over 33 days, so we would ask that you take no action because we would just file a 33-day motion and that he would be released on his own recognizance. So we ask that you don't revoke the bond.
State, would you want to be heard on that?
State has no objection to that.
All right, that's fine. We'll just take no action on that case at this time. All right, sir. Thank you.
Thank you, Your Honor.
You're all done. What was I looking at? Was this one? Okay. All right. Would you please state your name, ma'am?
Victoria Smalls.
All right, Ms. Smalls, you have been arrested on charges of driving while license suspended, second offense, failure to register motor vehicle, and attaching a registration license plate not assigned. The court has examined the arrest affidavit. Does either counsel want to be heard on probable cause, since I just quickly read it?
No, Judge. I didn't
Okay.
have it on.
I do find probable cause. At present, your bonds are set at $500 on the first count and $100 on the second two counts. Does PTR have anything to, does she qualify, or?
She has not been interviewed, so at this.
She has not been interviewed for PTR? All right. Anybody want to heard about the bond? All right, bond will be stayed at its present rate. Did I ask her about the public defender?
No,
You wanna
is
have-
the public
okay.
defender appointed? I know you have all the affidavits of insolvency.
Right. Do you, let's see, I don't have one on this.
You might not have one on this, but I know I don't have them like the Osceola PD does.
Okay, well, at least temporarily, would you like the public defender appointed to represent you?
Yes.
All right, then the public defender will be appointed, the bond will be stayed as I indicated, and probable cause is found. Sorry? Hold on one second, you have another case? Oh, okay. All right, sorry about that. You do have another case, and that is a charge of possession of controlled substance. I do recall having seen that in the arrest affidavit, the other one. So I do find probable cause to that as well. And on that case, your bond is set at $1,000. The court will appoint a public defender to represent you in that case as well. All right? Very well. Thank you for catching that.
Your Honor, she wants me to ask for you to reduce the $1,000 bond. She doesn't have any failure to appear according to the PTR face sheet. Looks like she has one adult misdemeanor conviction. There is juvenile history, but other than that, it looks like it's just one misdemeanor conviction.
What is the defense suggesting on that?
For the $1,000 bond reduced to $500 or $100 so that she can afford to take out on all these cases.
State?
State would have no objection to reducing.
That's fine. We'll reduce it to $100 on that one.
I appreciate it. Thank
The
you.
the other ones will stay the same, but that'll be $100.
Thank you, sir.
All right. Oh, on the possession case, we reduced the bond from $1,000 to $100. Just taking a moment to read this. Oops. All right, I've read the arrest affidavit. I do find probable cause for the offenses of burglary of dwelling, grand theft, third degree, and criminal mischief. The bonds in these matters are set at $5,000 for the burglary of a dwelling, $150 for grand theft, and $100 for criminal mischief. So would you like to have the public defender appointed to represent you temporarily?
Yes, sir.
Well, let's see if that's a temporary or permanent. Hold on a minute. All right, well, I do find that you qualify for the public defender, so I will appoint the public defender to represent you in this case during its pendency. Okay.
Your Honor, we would ask the $5,000 bond to be reduced to $1,000. He has indicated to me that he's having knuckle surgery next week, and he wants to be able to bond out so that he can get the surgery that he needs.
Okay. How'd you hurt your hand?
Upon coming
Got a little closer to the mic, can't quite hear.
upon coming to jail, I had got into an argument with the bouncer, and he slammed me on my arm.
Okay. PTR?
This is an add-on charge. He also has a warrant out of Volusia County.
Oh, out of what county?
Volusia.
Volusia County? So he'll, Mike, you're not doing anything of IAs on that today? You know, I'm gonna not reduce the bond at this time, because if you've got a warrant out of Volusia County, if you bond out, they're just gonna take you down there.
No, my warrant has a bond on it. It was only like it was a mishap. I've been going through the same charge with Volusia County. Every single time that I get in trouble, they give me a warrant on behalf of that case, and I go ahead and pay the bond. But I never physically get a court date on behalf of that charge.
Is there
I've
a
been
bond?
fighting this charge since 2017.
Is there a bond on the Volusia County warrant?
A $1,000 bond.
So ideally, he would bond out on these charges. Volusia will come pick him up within 24 hours, then he'll bond out of Volusia County. That would.
State?
72.
Your Honor, the state would request that the bonds be stayed at the amount.
I think based on the seriousness of the charge and if these charges are true, then you committed them while you were on probation for another case. I'm going to leave the bond as it is, at $5,000. So the bond will be stayed. Okay. That must be him. All right, is this Mr. Woodson?
It is, Your Honor.
All right, give me just a moment. Does counsel want to be heard on the PC?
No, Your Honor.
Okay.
Unless you have a sua sponte PC challenge.
Well, I'm concerned about the intent to sell aspect. Does either side want to?
Yes, Your Honor. I will reach out to the officer.
Okay,
So I'm requesting a 24-hour reset for that.
I don't find a whole lot here that shows intent to sell, so I'll give the state 24 hours to supplement the probable cause on count one. I do find probable cause on, well, is there count two? No, there's only one, okay. Well, it says possession of cannabis there. Is there a separate affidavit?
I have possession of cocaine with intent to sell. I didn't see anything.
Okay, somebody just wrote on there. All right, so we'll see you back tomorrow on that case. The bond is presently set, sir, at $15,000. And that bond will remain in place until we see tomorrow what law enforcement comes up with. Okay? And can I ask him about your services?
I believe we're already appointed on his other case, but you haven't addressed as far as this case.
Would you like the public defender appointed to represent you, sir? Yes?
He said yes.
Okay. I can't hear him, but I can see him. You're good. Don't move. All right.
Okay. Your
the
Honor.
court will. Yes.
Are you withholding action until tomorrow on the case he is out on bond on? That's where you saw the possession of cannabis.
Well, if you haven't found PC, you can't take any action on it today.
Well, I have found PC for possession of cocaine. I just asked the state if they want a time to supplement for the additional charge.
Okay.
So what's his charge that he's on bond on for now?
Possession of cocaine with intent to sell and possession of cannabis.
That must be what, I'm sorry. I do have that. That's what this is.
Yes.
Okay. Yeah, the court's going to revoke bond on the existing case, because my only question about PC was the intent.
Okay.
Yeah. So bond will be revoked on that case, and then tomorrow we'll address what the level of bond, if any, is on the main case. The new case, I should say. Okay. All right, why don't we take a break for a while, and I've got to review the rest of these. This isn't all of them, is there? Okay. So let's take a lunch break, and everybody can get something to eat, and I'm going to look through these. It's more efficient than making you sit and watch me read. And then we'll be back in like 45 minutes.
Okay.
All right? And I'll take them with me as I go to McDonald's or where it's close. Judge got to eat too, you know.
Yes.
All right, off the record.